Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. On 20th of this month, that is 2 days before, Honorable Supreme Court of India, two judges, Madam Indira Banerjee and A.S. Bopanna, while dealing with the case of Ranveer Upadhyay versus State of UP in SLP number 2953 by 2022, dated 20 April 2022, held that criminal proceedings cannot be quashed merely on the ground that they were filed by the political opponent to take political revenge or personal vendetta. There should be substance. The substance should be proved. How? Only through investigation. You can see the citation in Laila 2022 SC page number 396, in which Supreme Court held that criminal prosecution proceedings cannot be quashed under section 482 CRPC as the complaint is lodged by a political rival. Anybody has got the right to approach the court. So there are so many methods of filing a complaint. Number one, section 154 CRPC. What does it say? Whenever any person comes to the police station and reports the occurrence of a cognizable offense, a reporting regarding a cognizable, either orally or writing, it should be registered as an FIR. That is one. Suppose if there are certain cases categorized as non-cognizable cases, 155 CRPC. Suppose if you cannot go to the police station for so many reasons means, please remember, suppose when you go to the police station, they will not register the case. It is a civil matter, then even you don't want to go to police station, then you can straight away file a private complaint and it can be endorsed to the police under section 156 clause 3. All these three methods are there for getting an FIR registered or for getting a complaint registered. So this is the best thing, and it happened here, right? Please remember, actually the accused person, our Ranveer Upadhyay, is the accused against whom a case has been filed directly as a private complaint in the court. ADJ Hathras, it has Hathras, you may know Hathras rape case, Uttar Pradesh, it has become very popular, right? So ADJ Hathras, he took cognizance of the offense against Ranveer Upadhyay under sections 365, that is kidnapping, read with 511 IPC. So attempt to kidnap, it's only attempt to kidnap. So 511 section is used for attempt. Case 365 read with 511 means there was an attempt to commit the complainant in the particular case. And also an assault under section 3 clause 1 of the Scheduled Caste Scheduled Tribe Prevention of Atrocities Act 1989. So the complainant may be a Harijan or a Dalit. So right here the case has been registered, it has been taken on cognizance by the ADJ Hathras, and therefore this man has approached the first he approached the High Court of Uttar Pradesh, Allahabad, stating that or requesting the court to quash the proceedings under section 482 CRPC because it is a clear case of malicious prosecution initiated at the instance of the ex-MLA Devendra Agarwal, who is politically opposed to our accused person Ranveer Upadhyay. So you might have understood by now. So what he says is this is a clear case of a counter blast by the ex-MLA and a case of malicious prosecution. So now we have to discuss the law of torts. What is a malicious prosecution? How can it be taken as a tort? Please remember, whenever malicious prosecution is uttered, please remember, definitely the prosecution should be initiated with a malicious or bad motive. And please remember, the case should be struck down, and it has to come in favor of the accused person. And there should be some mention by the judge that this has been foisted, appears to have been foisted, case seems to be false like that. Then only you can for malicious prosecution. Of course, it's a tort law, very simple case. Here he has gone to the court for the so-called 482 CRPC. So that means they wanted to quash the proceedings. Here High Court did not do it. Ultimately he filed an SLP before the Honorable Supreme Court of India also. Honorable Apex Court has clearly stated that merely the complaint is filed by the opposite party. It does not stand in the way that the case has to be quashed. There should be some substance. So please remember the allegations at the outset. That means in the FIR they establish an offence under section S3 of SCST Act, and of course whether the allegations are true or untrue, they have to be finalized only through court trial or through the investigation by the police. So the decision will be taken only after the conclusion of a trial, and if they file the final report under section 173 CRPC. Of course, there also 173 clause 2 CRPC says that the complaint has got a he has got a right or leverage to not agree with the investigation of police. Then the trial will be conducted. So it will be decided later. Why so much of urgency? So please remember, the criminal proceedings cannot be nipped in the bud stage. You can't ask the court, ask the police to quash the FIR, not to proceed, because please remember, the police have got an onerous duty of investigating the case. They have to investigate the case. They have to find out whether it is true or not. Of course, you may be knowing truth is the goal of investigation. So therefore, merely basing on the surmise that the complaint was filed by the opponent party in order to take a political vendetta against him is not correct. The sum and substance, basically, of course, if the FIR is, if there is falsity apparent on the face of record, definitely the court can quash the FIR. But in such cases, where there are allegations of SCST, where allegations of attempt to kidnap, so and where there seems to be a prima facie material, the court cannot quash the proceedings merely basing on the complaint that it was filed by the politically opponent party. Good judgment, read it and enrich your legal knowledge. Thank you very much.